Welcome to the deep dive. You've shared a really thought-provoking set of materials with us,
Hmm.
all focused on that critical intersection of law and mental health, specifically here in Canada.
Yeah.
We're going to be exploring excerpts from Law and Mental Health in Canada, Cases and Materials, edited by Anita Seghetti and Dr. Ruby Hand.
Right, and with contributions from quite a few experts, too.
Exactly. Names like Jennifer Chambers, Cassandra DeMello, Carter Martell, Jacqueline Petrie, Sarah Rankin, Naomi Sayers, and Amy Shoemaker.
Quite the lineup. And our goal today, really, is to sort of dissect this important area for you.
To pull out the key insights.
Exactly. Sift through the complexity and highlight what's most crucial for understanding it all.
And it's worth flagging, like your sources point out, that mental health law as its own field. It's
Yeah.
relatively new, right? Maybe the last 3 years or so.
Yeah, roughly. But its roots, they go deep into civil law, criminal procedure, fundamental rights.
Right. And the book's dedication, it really hits home to people like Carla McCaig, Dawn Whites.
Mm-hmm. Champions for the rights of people with lived experience. It grounds the whole discussion, doesn't it?
It really does. Reminds you of the human element.
Absolutely. So, to give you a roadmap for this deep dive,
Yeah.
we're hitting some key themes from your materials.
Okay.
We'll start with lived experience, access to justice, kind of the foundations.
Got it.
Then navigate civil commitment, which can be complex.
Mm-hmm.
Then unpack consent to treatment, the nuances there.
Okay.
And finally, touch on how mental disorders intersect with the criminal justice system. An introduction, really.
Okay, sounds good. Let's jump into those foundational issues then. That statistic really stands out first about 1 in 5 Canadians.
Yeah, experiencing a mental illness in any given year, it's a significant number.
It really is.
And what that tells you is just the sheer volume of people who might, interact with these legal systems.
Makes understanding it crucial.
Absolutely. For a just society, really.
Mm.
And these issues, they don't exist in a vacuum, right? Things like racism, poverty, homelessness, discrimination, they can all worsen mental health.
Systemic inequalities.
Exactly. And tragically, Indigenous peoples face disproportionately higher rates because of these complex factors.
Right. Which brings us straight to the idea of lived experiences. Your sources really stress this.
Mm-hmm. How people with mental health and substance use issues face unique barriers in the legal system.
Barriers like stigma, racism.
Yeah, and how those things intersect, compound the challenges.
The materials also mention COVID-19. How did that impact things?
Well, think about congregate settings,
Yeah.
psychiatric facilities, for instance. High transmission risk.
Okay.
It disproportionately hit individuals detained under civil and forensic legislation. You had potential for big outbreaks, deaths.
Wow. And the psychological burden on top of everything else.
Exactly. A huge added stressor.
That paints a really concerning picture. The sources also talk about language, person-first language. Why is that so important?
It's fundamental, really, saying a person with mental illness instead of a mentally ill person. It puts the person first.
Right. Acknowledges they're more than their condition.
Precisely. It avoids re-traumatizing, reduces stigma. Even disability can be tricky sometimes.
So lived experience or mental health condition is often preferred.
Generally, yes. Seen as less stigmatizing, more respectful.
Makes total sense. Person first. And then there's cultural competencies and intersectionality. Sounds crucial given Canada's diversity.
Absolutely essential. Understanding mental health legally means seeing how experiences are shaped by race, culture, social factors, all intersecting.
You can't just look at one thing in isolation.
No. Studies show, for instance, that ethno-racial people with mental health disabilities face cultural and systemic discrimination.
Creating barriers to getting legal help.
Big barriers, stemming from experiences with racism, migration history, past trauma, maybe bad interactions with authorities before.
Okay, that's a really vital context to understand. Let's shift now to civil mental health law itself.
Right. So this area covers the legal rules and policies for individuals with mental disorders outside the criminal justice system.
So things like treatment, hospitalization.
Exactly. Protocols, involuntary hospitalization circumstances, that sort of thing.
And there are some key terms we need to get our heads around.
Definitely. Like treatment, basically healthcare for a mental disorder. Mental disorder itself has specific legal definitions, varying a bit by place.
Right.
Then you've got different patient types, voluntary, informal, and the key one for this discussion, involuntary.
Right. An involuntary committal, using Ontario as an example.
Yeah, that term really captures the legal situation where someone could be required to stay in a psychiatric facility against their will.
So the state stepping in.
Under specific legal circumstances, yes. It's a significant limitation on freedom.
And underpinning all this is the principle of consent, right?
Absolutely central. The right to refuse medical treatment. It's about dignity, autonomy.
And that applies even if someone has a mental illness.
Fully applies. But, and this is the key thing to grasp, there are specific, legally defined exceptions where treatment can happen without consent.
Okay. Specific circumstances only.
Very specific.
Your sources mention Starson v. Swayze. Why is that case so important here?
Pivotal case. The Supreme Court really clarified the test for capacity to consent.
Okay.
The big takeaway for you is, having a mental illness doesn't automatically mean you can't make your own healthcare decisions.
It's not an automatic disqualifier.
No. The court said capacity means understanding the relevant info and being able to appreciate the foreseeable consequences of a decision, or refusing.
Understanding and appreciating. More nuanced.
Exactly. It's not just knowing facts.
So just because someone has a diagnosis doesn't mean they lack legal capacity.
Correct. In fact, most jurisdictions have a presumption of capacity.
Meaning the starting point is that adults can make their own decisions.
Yes. And refusing treatment doesn't automatically mean someone is incapable.
That's a really crucial legal protection. What about emergencies, though, when immediate action seems necessary?
Yeah, the law allows for treatment sometimes, including restraint or seclusion in very specific emergencies.
What qualifies as an emergency?
Imminent risk of serious bodily harm or death to the person or others. Very high bar.
And restraint has a specific meaning, at least in Ontario.
Yes, in Ontario, it's legally defined as placing someone under physical control and only when necessary to prevent serious bodily harm.
Okay. And there are limits on how long emergency treatment can last.
Yes, typically limited by law.
Yeah.
And some things, like psychosurgery under Ontario's Mental Health Act, have extremely strict conditions.
Right, heavy safeguards. Okay, let's talk about civil commitment itself. What does that process involve?
So, civil commitment is the legal process for involuntarily admitting someone with a mental disorder to a psychiatric facility if they pose a risk.
A risk to themselves or others.
Exactly. It's a major legal intervention by the state. Restricts liberty significantly.
And it can't be done lightly. What are the prerequisites?
Absolutely not taken lightly. The criteria vary a bit across Canada, but generally,
Yes.
the person needs to be assessed as having a mental disorder, and that disorder is likely to result in serious harm if they aren't hospitalized.
And they aren't suitable for voluntary admission.
Usually, yes. That's typically part of it, too.
Your sources use Ontario's Box A and Box B criteria. Can you break those down?
Sure. So Box A in Ontario is generally about that demonstrable risk of serious harm.
Like previous threats or attempts? Or inability to care for oneself?
Exactly. Harm to self, harm to others, or serious self-neglect putting physical safety at risk.
And Box B.
Box B is more about the need for treatment in a facility. The person's mental disorder is such that without that specific
It's
treatment,
likely deteriorate substantially, mentally or physically.
right, or they've had a similar condition before, got treatment in a facility, and it helped.
So it's disorder plus risk, or disorder plus this demonstrated need for facility-based care.
That's a good way to put it, yeah. Two potential pathways.
The Thwaites case from Manitoba is mentioned. What was the issue there?
Thwaites was significant because the court looked at whether Manitoba's involuntary detention criteria lined up with the Charter of Rights and Freedoms.
And
Well, the Court of Appeal raised concerns, said the existing dangerousness or risk of feared harm criteria might be too broad.
potentially infringing on liberty unjustifiably.
That was the concern, yes. It highlights the ongoing legal balancing act.
Definitely a tough balance. Once someone is committed involuntarily, is that it? Indefinite?
Oh no, not intended to be indefinite. There's a process for renewing the detention. Regular reassessments are required.
To make sure the criteria still apply.
Exactly. There are maximum time limits for the initial certificate and for renewals. Varies by province, but ongoing justification is key.
Okay. And then there are community treatment orders, CTOs. How do they fit in?
CTOs are an interesting approach. They aim to prevent or reduce the need for repeat hospitalizations by allowing someone to live in the community, but under specific conditions, usually including supervised treatment and support.
So, structure and support, but more autonomy than being impatient.
That's the goal, yes. Trying to balance care with community integration.
Shifting back to consent for a moment, the idea of substitute consent comes up. When is that used?
That comes into play when someone is legally found to lack the capacity to make their own treatment decisions.
So if they can't consent themselves.
Right. The law then allows someone else, a recognized substitute decision maker, or SDM, to make those decisions for them.
And the SDM has to act in the person's best interests.
Always. That's the guiding principle.
What about minors? How does consent work for them?
Well, there's the common law concept of the mature minor,
Meaning?
meaning a young person who understands the nature and consequences of a treatment might be able to consent themselves, even without parental consent.
Depending on their maturity and understanding.
Exactly. Plus, there's specific legislation in different places about substitute decision-making for minors, too.
Okay. Now, it sounds like the actual definition of capacity might vary a bit across Canada.
That's a sharp observation. Yes, there are some differences in how capacity is legally defined and applied.
Like in Ontario.
Ontario's Healthcare Consent Act, for example, focuses on the ability to understand the relevant information and appreciate the reasonably foreseeable consequences of a decision, or not making one.
Understand and appreciate again. That seems key.
It is.
And the Nieto v. Klukash case reinforces this isn't just theoretical.
Absolutely practical. The court in Nieto warned against automatically equating a mental disorder diagnosis with incapacity.
Right.
And stressed how vital it is to consider the patient's own values, beliefs, priorities when assessing capacity. Very person-centered.
Got it. What about McLaren v. British Columbia? What was that about?
McLaren was interesting. The court granted public interest standing, basically allowing a challenge to BC's Mental Health Act.
Challenging what specifically?
What are called deemed consent provisions for psychiatric treatment, raised big questions about individual rights versus state authority.
And just quickly, Alberta and Manitoba, any specific points on substitute consent there?
Yeah, both have specific laws, often involve review panels for oversight on SDM decisions.
Extra scrutiny.
Right, and the public guardian and trustee often plays a role, especially if there's no other suitable SDM.
Okay. Let's move to guardianship and powers of attorney. These sound like important tools when capacity is an issue.
Very important. Guardianship is a formal legal relationship set up by a court when someone lacks capacity for certain decisions.
And the court appoints someone else, the guardian.
Exactly, to make those decisions. The research you shared suggests over 50,000 people in Canada are under some form of guardianship or substitute decision-making.
Wow, that's a lot. What's the core idea of guardianship?
It's a legal transfer of decision-making rights from the person deemed incapable to the guardian.
And the guardian must act in their best interests.
Always. That's the legal obligation. And guardianship orders can cover different things,
Right.
healthcare, where someone lives, social stuff.
Okay. Are there less restrictive options than full guardianship?
Yes, thankfully. There's growing focus on things like co-decision-making and supported decision-making.
How do those work?
They aim to assist an adult with capacity challenges rather than taking over completely, respecting their autonomy, helping them make their own decisions as much as possible.
More collaborative.
Exactly. Providing support, not substitution, where feasible.
And adult protection legislation, what's its role?
That provides a framework to investigate and intervene if an adult with capacity issues might be suffering abuse, neglect, or even self-neglect.
A safety net for vulnerable adults.
Precisely.
The HAV Fraser Health Authority case from BC is used as an example. What did it show?
That case really highlighted the core procedures for guardianship, especially in emergencies, and the potential legal pitfalls.
What happened?
The court found charter violations. Things like not giving enough reasons for detaining the person and putting limits on their rights without proper justification.
So it underscores the need for due process, even in emergencies.
Absolutely. Fundamental rights still apply and must be respected.
Okay. Now, a really sensitive topic. Personal health information in mental health law.
Yeah, hugely important. Privacy and confidentiality are critical here, especially because of the potential for stigma and discrimination.
Still a very real issue, unfortunately.
It is. So protecting personal health info is paramount.
And there are specific laws for this.
Yes. Like in Ontario and BC, as your sources mentioned,
Absolutely.
statutes govern how personal health information can be collected, used, disclosed.
By who? Hospitals, doctors.
By health information custodians, yes. Hospitals, clinics, individual providers. The laws also set out individuals' rights to access their own records.
Though there might be exceptions.
There are, usually if disclosure could cause harm to the person or someone else, but the general principle is access.
Got it. Okay, hey, finally, let's touch on that complex intersection. Mental disorder and the criminal justice system.
A very complex and frankly concerning area. Your sources flag this trend of increasing forensicization or criminalization.
Meaning people end up in the justice system when they really need mental health care.
That's often the dynamic, yes. Frequently linked to a lack of adequate community-based mental health resources and support. The system becomes the default, inappropriately.
Your materials specifically mention looking at this through a lens of race?
Yes, critically important. The sources emphasize doing a race-based analysis, particularly regarding policing and the justice system.
Pointing to issues like
The significant overrepresentation of Indigenous clients within the criminal justice system raises fundamental questions about systemic bias and equitable access.
a really crucial point to consider.
Absolutely.
Well, this has been incredibly informative, a real deep dive into a vital area of Canadian law. Just to quickly recap the ground we covered for you. We started with the Foundation's lived experience, access to justice.
All right, the human context.
Then navigated civil commitment, the legal framework there.
An involuntary aspect.
Explored consent and capacity, who decides and how.
Including substitute decision-making.
Right. And finally, we introduced that complex interaction between mental health and the criminal justice system.
Yeah, a brief look at a big issue. And as we've seen, all these legal areas are really interconnected and deeply impact people's lives and rights.
The question, it's multifaceted stuff.
Definitely requires ongoing thought and careful handling.
It certainly does. And it leaves me with this final thought, something for you to ponder. As our understanding of mental health keeps evolving, how do our laws need to adapt? How do we best balance that crucial need for individual autonomy with the state's role in providing care and ensuring safety, especially for those facing mental health challenges?
That's the core tension, isn't it?
It really is. It's a landscape that's constantly shifting and one that definitely needs our continued attention.